Understanding JCAM Articles 16, 17, 18, 19, and 20. Welcome back. Today, we are continuing our comprehensive walkthrough of the Joint Contract Administration Manual, or JCAM, by examining Articles 16, 17, 18, 19, and 20. These 5 articles govern the disciplinary process, steward rights and representation, the federal prohibition on strikes, the enforcement of postal handbooks and manuals, and carrier parking rights. Let's break down each one step by step. Part 1, Article 16, Discipline Procedure. We begin with Article 16, which is one of the most vital articles in the contract because it protects letter carriers against arbitrary or unfair discipline. Article 16 establishes that management may only discipline an employee for just cause. Discipline must be corrective rather than punitive, and it must follow a progressive path under normal circumstances. This progressive sequence moves from an official discussion, to a letter of warning, to a 7-day suspension, to a 14-day suspension, and ultimately to removal. Before issuing any formal written discipline, management is required to conduct a thorough, objective pre-disciplinary interview, or PDI, to investigate the facts and allow the carrier to respond with steward representation. Furthermore, Article 16 requires a higher-level authority, such as a postmaster or manager, to formally review and concur in writing with any proposed suspension or discharge before it can be issued. To see Article 16 in practice, imagine a supervisor hands a letter carrier a 7-day suspension for attendance without ever having issued a letter of warning first, and without conducting a PDI to ask for the carrier's side of the story. Because discipline must be progressive and corrective, and because management bypassed the mandatory investigative PDI, the suspension lacks just cause and violates Article 16. Part 2, Article 17, Representation. Next is Article 17, which guarantees the union's right to represent letter carriers and establishes the specific rights and access granted to NALC shop stewards. Article 17 ensures that employees have the right to union representation during any investigative interview that the employee reasonably believes could lead to discipline, a principle known as Weingarten rights. When an employee requests a steward, management must halt the questioning until representation is provided. Article 17 also dictates how shop stewards perform their duties. Stewards have a contractual right to investigate, write, and process grievances on duty time without loss of pay. When a steward needs to investigate a potential grievance, management must grant them reasonable official time upon request, unless doing so would cause a severe, immediate operational emergency. Stewards also have the absolute right under Article 17 to access postal records, time cards, route inspection documents, and station records needed to process grievances. To illustrate Article 17, suppose a steward requests 1 hour of official duty time to interview witnesses and review time cards for an active grievance that faces a strict filing deadline. The supervisor denies the request, stating, "We are too busy today, you can do union work on your own time after your shift." This blanket denial violates Article 17 because management is contractually required to provide reasonable official time on duty for stewards to process grievances. Part 3, Article 18, No Strike. Moving to Article 18, this article addresses the absolute federal prohibition against strikes and work stoppages within the United States Postal Service. Article 18 states that the union will not call, encourage, or participate in any strike, work stoppage, slowdown, or intentional interruption of postal operations. Because federal law explicitly prohibits postal employees from striking, the collective bargaining system provides interest arbitration as the legal substitute to resolve negotiations when the national parties reach an impasse. In return for the prohibition on strikes, Article 18 guarantees that management cannot lock out employees or prevent letter carriers from working their scheduled assignments as a tactic during labor disputes. For a practical example of Article 18, suppose contract negotiations between the NALC and the Postal Service reach an impasse at the national level. Local carriers cannot organize a sick-out or picket line to halt mail delivery as a pressure tactic, as this would violate Article 18 and federal law. Instead, the contract mandates that unresolved disputes must be submitted to a neutral, binding interest arbitration panel. Part 4, Article 19 Handbooks and Manuals. Next is Article 19, which acts as a bridge incorporating official Postal Service handbooks, manuals, and regulations directly into the national agreement. Article 19 establishes that any portion of postal handbooks, manuals, or published regulations, such as the M41 City Delivery Carrier's Duties and Responsibilities, the M39 Management of Delivery Services, or the Employee and Labor Relations Manual, ELR, that directly relates to wages, hours, or working conditions is contractually binding. Management cannot enforce any rule in a handbook or manual that conflicts with the national agreement. Furthermore, if management wishes to change any rule or handbook policy affecting working conditions at the national level, they must notify the NALC 60 days in advance and give the union the opportunity to challenge the proposed change through national arbitration if it violates carrier rights. To see Article 19 in action, suppose a local supervisor mandates that all carriers must case their mail at a pace of 25 letters per minute, threatening discipline if they do not hit that speed. Because the M41 manual defines the contractually recognized casing standard as 18 letters per minute and 8 pieces of flat mail per minute, management's arbitrary new standard conflicts with established handbooks, creating a direct violation of Article 19. Part 5, Article 20 Parking. Finally, we examine Article 20, which governs employee parking rights and facility accommodations at post offices and postal installations. Article 20 requires management to continue existing employee parking practices at postal facilities. If a post office currently provides dedicated employee parking spaces or spaces for personal vehicles, management cannot arbitrarily eliminate or reduce those spaces without a legitimate operational justification. Additionally, Article 20 mandates that when new postal facilities are constructed or existing facilities are redesigned, management must make reasonable provisions for employee parking in the design plans. For a real-world example of Article 20, consider a station where carriers have parked their personal vehicles in a designated back lot for 15 years. A new postmaster decides to block off half of the employee parking spaces to store extra unused postal trailers, forcing carriers to park on distant public streets. Because management unilaterally eliminated established parking without bargaining or operational necessity, they violated Article 20. Conclusion. In summary, Articles 16 through 20 safeguard essential rights and operational rules. Article 16 ensures discipline is fair, progressive, and rooted in just cause. Article 17 guarantees steward representation and official duty time. Article 18 maintains continuous service under federal law. Article 19 enforces official postal handbooks and manuals, and Article 20 protects employee parking privileges. Thank you for watching. As always, consult your local shop steward or the JCAM for specific grievance applications at your station. Stay safe, stay hydrated, and work at a pace you feel is safe.